right, welcome. Good evening to all our esteemed panelists. Ladies and gentlemen, that was a beautiful, intense, very energizing session. So we're going to try our best to keep the energy levels at the same place. I'm sure everyone has really enjoyed the last 2 days. I feel very privileged actually to be here to discuss at this opportune moment at SecuFest all the updates that's happened in decoding India's data privacy law 2.0. This is really what better platform could we ask for than this one to really understand what the amendments have, what amendments have been made, how they can be applied practically, how any, key features, implications that have been missed in the previous versions have been put into effect today. So here we are today. Without further ado, we're going to deep dive right into it. Once again, welcome to all our very esteemed panelists. We have industry experts here to really help us decode the law and all its amendments. So at the onset, I would just like to welcome everyone and ask everyone for a quick round of input on any significant feature, or rather the most significant feature that you can share that has been put into the Data Privacy Law 2.0 and how this differs from the previous version. Let's start with you, Ambarish.
Hello. Good evening, everyone. I think after this last session, it's difficult to hold you, but we'll try to do justice. We all are probably, I think none of us are the privacy officers, but we'll try to do justice what we can do. So, privacy, post GDPR, which came into light, every country started making their own privacy law. And all depends upon the country's their own ecosystem, their culture, their economical systems, their political will, geopolitical ecosystem, etc. And the previous version has a lot of things, and now the new version is one point I'll talk about is they talked about that they have done do away with the data residency. It means data will reside in India. Now what they have said is data can be shared with the friendly nations, and that list will be given by the government of India. And recently, last week I was part of one of the ISMG event where the Supreme Court lawyer was saying that now government will not give you the list of whitelisted countries, they will give you the list of blacklisted country where you cannot share the data. It means apart from those countries, you can share data with anyone. However, there will be some riders for the different sectors, maybe BFSI, etc. I think that will be governed by it separately. And that is, I think this is my initial thought.
All right, thank you. Praveen, opening comment, one significant feature of the Data Privacy Law 2.0.
Before coming to the significant feature, I'll pick up a few lines from Mr. Ashutosh Rana. He said, accept, acknowledge, and appreciate. I think we are in that state with respect to data privacy law. It's high time we accept it. We've been talking about it for over a decade now. India being the most digital country in the world, the number of internet users, 670 million plus. And we've been waiting for this law for quite some time. There have been various versions of it. The first version they said was too complex. Now the second version they are saying is too simple. But I think it's time we accept it. We take those baby steps. We acknowledge it because most of us sitting over here would be toying with the thought that karna kya hai abhi? It's high time we understand it, we try to understand it and start working towards implementation. Thirdly, I appreciate it because two key aspects I pick up from not getting too technical. First thing, it's very simple. Keeping it simple is the best way to start anything. For example, if you're let me take an example of starting a sock. We cannot reach the best sock on day one, right? We need to take those baby steps. And that's where this law is. Second is they have not tried to regulate the technology too much. The same law or the bill can be used to embrace any technology. Let it be the NFTs of today and tomorrow, the blockchain world. It's not binding the way technology has to be implemented. They've kept it very open. I think these are the two major factors which I think would find acceptability amongst the industries as well as the users.
Right, thank you. Praveen?
I think most the high-level features are covered. So let me talk what is there in the draft bill. Okay, so the draft bill talks about setting up a data board. Okay, our data board is an independent body, and one thing which is very different from it is that data board is equivalent to a civil court. So it has a power of civil court, and it can use state government or central government agencies to perform any kind of operations or activities they want to perform. So they have been empowered as well. Okay, and also they have the option to exercise or change their decisions. So that there are multiple features in it. But then the data board is an independent and a powerful organization. So that makes it an independent body. That's the best thing I can say.
Thank you for that. Krishnendu.
So well, thank you so much for bringing up this topic in the first place. I would say, like, there has been a lot of amendments in the bill, and I think our panelist so far has, like, kind of pointed out the best points. What's the best unique part that I find about the bill is basically the rights that you provide to a citizen, and this was, I think, like, acknowledged in the GDPR bill itself. And I think after this comes into picture, we as citizens as well are secured, because, no entity can misuse the data. And even if they do, we still have the rights to exercise, how do we control that information? So that is one of the biggest highlights. I would also love all my other panelists to speak about, like, the other unique points itself. So, but yeah, that's one thing which I feel it's the distinction.
Thank you. Citizen rights, thank you for sharing that. Shyamlee, let's move on to
you. A very good evening to everyone. I think this is an important and very relevant topic, and extending it from, my co-panelist here, I think the important aspect which I would want to emphasize on is the change in the penalty clauses that have come into play. And that is predominantly from the onset that, now that we have a culture of, or an ecosystem of startups where we need to give them a very conducive atmosphere of them to thrive and, encourage the entire ecosystem. To that extent, there's a lot of flexibility given in the way this entire bill has been drafted in context of, the ability for a startup ecosystem to innovate and co-create in that space. I think that's a very, very important aspect. Otherwise, it might, be read as a deterrent, which is not the case here. It's very much flexible in terms of the limits of the, capping which has been done with respect to, the penalty. But yes, there is flexibility, and a good amount of lever or leverage has been given for the startup and the industry to kind of play around and work through the innovation channel. So it's more around encouraging and giving an opportunity to lever further up the antennae towards innovation engine. I think that's an important takeaway from this.
Thank you. Thank you, Shyamlee. Biju?
Yeah, good evening everyone. My perspective is so India badly needs a privacy law. So we all know that the digitization and digitalization that have been happening across the previous years, now we all live in a digital era. So a law which protects us from the misuse of our personal data, that is very much the need of our. So though earlier the draft bill, the Sri Krishna committee report was published, compared to that, the 2022 bill is very much simplified. And the main advantage, as I would say, is that from an organization perspective and also from a data privacy officer perspective, the implementation part has been very much simplified. So like Mr. Praveen earlier mentioned, to start from ground zero to the first version 1.0, so it has been made very much simplified. And other aspects like the scope for the removal of the scope for criminal offenses, those kind of aspects is actually a very blessing, particularly when we are about to implement this. So that's my view.
All Right, thank you. Thank you to all the panelists for really sort of setting the foundation and the framework of the new law and the amendments that have been made. Krishnendu, let me start with you now, deep diving a little bit further. To continue with this trend of understanding the framework before we go deeper into it, can you help us understand how this law defines personal data as well as sensitive personal data? And we'll use that as a starting point.
Absolutely. Thanks for the question. And that's absolutely a great question because today we first need to understand the definition well. So when we talk about the personal data, it's anything that can identify an individual directly or indirectly. So it could be your name, email address, telephone number, your postal code, postal address, PIN code, lot of things actually which comes into picture. But you know, in the previous draft, we also spoke about the sensitive personal information. So when we talk about sensitive personal information, it's about the ethnicity, you know, the religious views, okay, and like, you know, sexual orientation, and there are a lot of other factors actually which talks more about the sensitive personal information. In this, the current draft, that has been eliminated. Actually, we are just left with the personal information aspect itself. So yeah, that's the only difference that we see, yeah, in the current bill. Yeah.
Thank you. Praveen, let me bring you in on this. We've understood the difference between personal and sensitive personal and the new amendments in the Act. But there's also a lot of terminology left to decode. We hear about fiduciary, deemed consent, critical personal data. Can you help us get a little more overview on the terminologies and what your approach is?
So one of the, I would say, the negatives of this bill, if we can say so, I can't say it is actually a negative, but the use of non-standard terminologies. You know, whenever we talk about data privacy, the first thing that comes to any of our minds who have implemented any data privacy policies in your respective organizations would be GDPR. In fact, you know, if you know, my organization, which operates in more than 100 countries, when I am told to implement privacy laws according to the countries, first thing I do is pick up GDPR and do a comparison with various laws across countries. And more often than not, you find that most of the controls map with GDPR, which means that if you implement all the controls required for GDPR, you're compliant with all other data privacy laws. But this bill per se has made I don't know what the reason is, but yes, they have made a specific effort to divert from the standard terminology and use certain terminologies which are not standard, which means that we cannot directly relate to what exactly they are saying. Some examples I can give you. The data subject has become a data principal. Data controller has become a data fiduciary, right? The legitimate interest has become deemed consent. You know, what essentially happens is that it becomes very difficult to interpret or map controls with respect to these particular terminologies. I'll give you certain examples. For example, deemed consent, one of the most widely debated topics. What essentially deemed consent means is that for every time you want to process certain data, personal data, you need not go in for a consent. You know, there are certain cases where you can consider it as a legitimate interest of the organization and continue to process it. But the same thing has been named as deemed consent. What it essentially means, what a common man starts interpreting is that if the organization or the business feels that the consent is deemed, they'll continue to process it. For example, you know, we all gave our mobile numbers and names to ETCISO, right? Tomorrow, if a cab driver calls you because ETCISO has shared the number with them, it is considered to be as a deemed consent. We don't require to, ETCISO does not require to take a specific consent. It is a legitimate requirement of the business, that's why it's been shared. Similarly, another debated topic is data fiduciary and significant data fiduciary. Though this is not termed like this in GDPR, but yes, it clearly you know, brings out the concept of a data controller and a significant data controller. What it essentially means is that we cannot paint the whole canvas with the same brush. You know, a small organization which may be processing certain amount of data, but the data is not at scale, or an organization which is a startup which does not have, which is not in a state to implement all the strict controls which the law wants us to, they are given certain amount of leeway till the time they scale up to a certain level. So these are some terminologies which are creating a lot of confusion, but however, there is surely one-to-one mapping with them. There is a requirement for us to, probably look at it and in greater detail and understand it better.
Thank you. Well, now that we have a little more clarification on the terminology, the foundation, Biju, let's bring you in on this to talk about enforcement of the new law. What role will the Data Protection Authority play in the enforcement, and what powers do they have at this point?
Yeah, so Data Protection Board, earlier it was Data Protection Authority. In the current latest 2022 bill, it is named as Data Protection Board. And as per the details provided in the draft, Data Protection Board will have vast powers. So primarily, Data Protection Board will be the authority who decides the level of compliance each organization has with respect to the requirements of the Act. That is their topmost power. Then again, if there is a complaint, they are supposed to, and they can do inquiries that determine the level of compliance and decide on the penalties which are applicable based on various actions or based on various scenarios, like, so what was the impact of that particular leak, whether somebody gained from that, what's the loss to those data subjects, whether the organization from where the data has leaked has acted promptly, what are the steps taken by them to minimize the damage. Like that, various factors the Data Protection Board can consider before awarding the punishment, that is whether it is 200 crore or 50 crore or 10 crore. So basically, Data Protection Board will be the final authority as far as the level of compliance, the level of punishment, whatever it is. Again, so the decisions of the Data Protection Board, as earlier mentioned, it cannot be challenged in any criminal court or civil court. At least it should be in the High Court. So like that, they are having vast powers. So this will empower them to ensure proper implementation and also the proper level of compliance across the industry. Thank you.
Thank you. Praveen, let's bring you in on this, as Biju's touched upon the penalties. This is actually a hot topic on this panel, as we've been discussing a little bit before our session. Can you take us through the penalties for non-compliance with the new law and where it stands today?
Yep. So the penalties, I think the penalty would be applicable when the board performs an inquiry, and if they find guilty, okay, based on their observations, they can levy a penalty up to 500 crores, okay. And there is a Schedule 1, where there are 6 type of activities where they are mentioned, and the penalties range from 250 CR to 10,000 rupees. So it could be any one of the 6 or all of 6, but then the maximum would be up to 500 CR. And of course, the amount of penalty would be dependent on the nature of the impact, what is the impact that the activity had, the losses which have incurred, the state of the company, what did the company do to protect this event, was it intentional or unintentional. So there are multiple 6 parameters which would be studied, and then the penalty would be levied.
Thank you. Shyamlee, let's bring you in on this, your perspective on the penalties and how this is going to impact companies and industry moving forward.
So I think, in this entire framework, penalty aspect earlier, served as a, the idea is that this should serve as a deterrent to an extent, but at the same time it has to balance and create an ecosystem, as I mentioned earlier, right, where you can still have that opportunity to innovate, because India, with the growing hub, right, the way it is, and more of, the avenues for us to increase our footprint, I think the idea is to, do the right amount of balancing out there to carve it out at a different level. And as you mentioned, Praveen, there were multiple levels around the amount of impact, the kind of breach, the amount of, the collaterals that actually gets damaged. I think the intent is towards that. But I think to the larger, I would say the players, the tech players, I think this is the cap amount is quite less, because when you're talking about data moving, I mean for the tech giants, if you're talking about, there's so much of information and value in the data that they have, and once the moment they're moving the data out of India, I think the amount of impact on the penalty at a 500 crore is relatively less. So that should definitely be an opportunity that, it could be relooked at the way, you're comparing this capped amount as a capped when compared to the tech giants, because they could just, fuel the entire data, and that they could earn, when you talk about every record or every data, it's equivalent to about a $150 kind of, you translate the amount of humongous data value that you're going to derive from it, the penalty is not in line with that. So maybe that is an opportunity for us to relook and for the drafts group to relook at and possibly up and cap that out to limit that this thing there. Yeah.
Thank you. Thank you for your perspective. Ambarish, let's also bring you in on this. We're talking about cross-border data transfer and some of the challenges faced there. How does the new law address these issues?
So, as I said previously also, these all the data transfer between the countries, among the country, continents, etc. GDPR has their own requirements, depend upon their own country requirements, business setup, geopolitical engagement, etc. In India, this privacy bill has said that, as I said, last week somebody was talking about, now they're going to give us the blacklisted countries, not the whitelisted countries. It means they're making their job easier, that some countries you cannot share the data at all, and rest all the countries you can share the data. Now the nitty-gritties will come up. I think the draft bill, once it comes to the public, again, I think they may put up again for the public review, or maybe this bill may become an act. So we are still awaited, and we'll see how it frames up.
And what insight can you give us on how organizations today are really approaching the big issue of privacy, cybersecurity and protection of PII data? Where do organizations stand at the moment?
Yeah, so to adhere to the respective privacy laws, we need to understand which all the countries you operate in. So to safeguard the data, PII data, sensitive PII data, we need to understand which are the country or continent you operate in, first thing. Second thing is you need to understand where is your PII data residing. That is very important, mapping of the data. I think last 4 or 5 years, every organization, if I'm not wrong, has done some or other activity. I see bunch of consultants, bunch of applications are being built to map out where your PII data is. That is very important to understand, first thing. Second thing, you need to understand what are the controls we have built in to safeguard the data. Okay, so probably take example of from the access control to the encryption, etc. Because as Praveen was talking about, penalty is going to be once things may break, things will go wrong, but they are going to look at what due diligence we did as an organization to safeguard the data. That is very important. Third thing is we have an incident response plan for the other cyber breaches. We need to bring in, when there is a cyber breach or there is a data exfiltration for the PI data, we need to bring in, we need to have a right process in the incident response process, that we need to bring in DPO and legal framework, so that to whom to inform at what point of time. Because generally, if there is a business data, the data is breached, but there is a financial data. So nothing to do with the PI data. We need not to inform the customer. If there is a breach and it amounts to the breach of PI data, then we need to follow certain guidelines, certain very strict timelines to inform the respective customer, respective stakeholders. If you don't do it, even if just not informing about a breach of PI data to the DPO or respective authority, I think around 200 crores, I think, if I remember correctly, is the fine. Not informing about the breach itself. I think that's sensitive this matter is.
Thank you.
Just add on to that part. One thing which the most important thing which comes to our mind whenever we are talking about privacy is that annoying pop-up which comes up on a screen, consent, right? Agree or do not agree. What I wanted to tell was that data privacy is much more than that, much more than that. Just by implementing a consent form onto the screen would not make us, we are not adhering to the data privacy law. most importantly, we have to start thinking at the design stage itself about privacy. What we call as privacy by design. Whenever we're designing an application, we'll have to, the security folks have to sit with the application and the business teams and understand that is the right amount of data is being captured. Whatever data is being captured, does it really require to be captured? Whatever data is being transferred from, from our business to some other business, is it legitimate? These are the concerns which probably would require a larger thought process than just implementing the, concern.
Well, thank you to all our panelists. In the interest of time, we will be wrapping up now. But I do encourage everyone to continue this conversation. And perhaps we can talk about the focus areas for 2023 offline. When we go back, we continue with networking. Really pertinent topic. And I think you've shed perfect light and set the foundation for the conversation moving forward the rest of the evening. Thank you so much for being with us.
Just one thing. I really want to acknowledge, the Economic Times team, especially Shantri ma'am, as well as Soumya, actually, because she has been doing all the coordination all together, and to you for moderating this particular panel discussion. We have seen all these cyber security discussions into picture, but I think this is a hot topic at the moment actually, and if we don't take an action now, then I'm pretty sure it's going to be very hit. It's going to be a problem for a lot of organizations itself. Thanks for bringing up this topic, and thanks, and cheers to the Economic Times
Thank you.
team.
Thank you so much, Krishnendu. Really appreciate it on behalf of the entire team.